Yeah, hi guys. Today let's try to understand Section 124 of the Indian Contract Act, which is basically the beginning of special contracts. So this section talks about indemnity. What is the meaning of indemnity? It basically means, as per the dictionary meaning, it means that it is some kind of protection given against a loss. By whom? Let's see. It also means to compensate for the loss which happens or which occurs to a person by another person. Compensation is done by another person for the loss incurred by a person. It also means to make good the loss which has happened. To make good means to compensate, basically. So, okay, let's see what happens when we have this word indemnity. With that indemnity, basically it's a contract. So with that we have the word indemnifier. One who indemnifies is called as indemnifier, and one who is being indemnified, that is indemnity holder. Now, what happens? These are basically promisor and the promisee, what we have studied in the contract definitions. So, promisor and promisee. Who is the promisor here? One who is indemnifying. Let's see what happens when there is loss incurred by the indemnity holder, which is caused by the indemnifier himself or any other person. This loss is made good by the indemnifier, that is, it is compensated by the indemnifier to the indemnity holder. So it basically means whatever loss happens or whatever loss is incurred to the indemnity holder shall be compensated by the indemnifier, even when this loss is caused by any other person. That is the contract of indemnity. It's basically a contingent contract where an event has to happen for this contract to be executed. That is, the loss has to happen. So let's understand the definition. It's basically the contract of indemnity defined. So you can see that the elements or the ingredients of the section is, that means there should be a loss, yes, and for the loss must be caused by the promisor or the person, any other person. So that is also there. Plus here we have the liability which is fixed on the indemnifier to compensate this loss. Okay. Hope we have understood the definition of that indemnity, contract of indemnity. Now let's try to understand with an example. In fact, with the case law, very popular case law, Adamson versus Jarvis. Jarvis here reminds me of this computer in, I think, Iron Man, yes. This is not that Jarvis anyways. So Adamson is the plaintiff who sells or who sold to the buyer B. What did he sell? He sold cattle to the buyer B. Why did he sell this? I mean, what made him sell this? It is on the instruction by Mr. Jarvis, who is the defendant in this case. This cattle didn't even belong to Mr. Jarvis. So the buyer sued Adamson, and Adamson in turn sued Mr. Jarvis. So in this, the court held that Mr. Adamson's actions were indemnified by Mr. Jarvis, that is the defendant, and he is liable to make good the loss incurred by Mr. Adamson. So this is the case law. Thank you. Next one. Very important thing what we also need to understand here is every contract of insurance is a contract of indemnity. Well, if every contract of insurance is a contract of indemnity, then we do have an exception here too. That is, the life insurance is not an contract of indemnity. Now let's look into this life insurance in the next slide, but here, what are the losses covered by such contract of indemnity? It could be an accident, fire, and also natural calamities. That means any loss which the indemnity holder incurs due to these, which are usually covered by the insurance. So the accident insurance, fire insurance, and natural calamity insurance. Okay. Now let's move on to the life insurance thing. Why it is not called as contract of indemnity? It's like there is an accident, or maybe there is a theft of your bike, and it's covered under the insurance. The insurance company provides compensation, and you can buy a new bike which is similar or the same brand. But what happens with life insurance? Life cannot be replaced. If X person is dead, the insurance company will not replace that person, but instead the indemnity holder, instead the compensation is given to the nominee. The second reason is the indemnity holder no more exists and the nominee is compensated. In the sense, if you lose something, for example, if you have a laptop and you are the indemnity holder, and there is some damage or you lose the laptop and there is insurance covered for it, you can buy the laptop because you are the indemnity holder. You are compensated. But here in life insurance, the indemnity holder himself is not living. He is no more. So due to these two reasons, life insurance is not categorized as a contract of indemnity. Of course, we explained the reasons. Okay. Now, other case laws for further understanding: Dugdale versus Lowering and Sheffield Corporation versus Barclay. And Section 125 speaks of right of indemnity holder and has nothing in clear about the right of the indemnifier. So let's speak about that in the next video. Thank you. Bye for now.